Hey everybody, it's Christopher Small with CMS Law Firm, here to talk to you about some estate planning, some tax planning today, all kinds of fun stuff, and I hope you enjoy it. Before we get there, as always, if you do not have an estate plan, you're crazy, and you need one, and you should go to estatemeeting.com and book a time to talk to me about it. Even if you don't sign up, at least you'll understand the risk that you're taking by not doing anything. And you can make an informed decision not to do anything, okay? Just burying your head in the sand saying, I don't like to think about death, or I'm too busy. Those are excuses. They're gonna come back to bite you someday. I don't want that for you. So, estatemeeting.com. All right, now, let's talk about today's topic, which is estate planning related because we're talking about gifting. It's also tax related. We're talking about how to avoid excise taxes on a real estate sort of gift, and also how to get rid of capital gains taxes, at least a little bit of capital gains tax that you might have on a gift. So this was a question that my buddy and my CPA and also a tenant in my office, Moses Mann, came in and talked to me about today. He had a client that had a question about this, and I thought it was an interesting question, so I want to talk to you about it too. And basically, what happened is there's a person that owns a house, and one of his family members is living in the house, in this house, and he wants to get rid of the house. He wants to eventually, but he doesn't want to pay capital gains taxes on it, so he wants to give it to his relative that's living in the house, and not pay any excise taxes on it either. Excise tax is basically when you transfer real estate via a sale from one person to another, you pay tax on it, okay? In Washington State, you're paying taxes on everything because there's no income tax. So they nickel and dime you, so you feel good not paying any income tax, but you still pay a significant amount of your income to the state because they get you with all these other higher fees. A perfect example, to record a deed in Washington State, it's $109. Like in California, it's $27. So there you go. So we were talking about this, and we came up with a pretty cool idea. Moses came up with most of the idea. I'm going to regurgitate it to you because that's what I do. But I did come up with part of this idea. The other thing that happens is, what do you do if you have a mortgage on the property, and you want to transfer this via gift, and you're worried about the bank calling the loan on the mortgage that you have on the property? So to recap real quick, we have a scenario. We have a person A that owns a property. Person B is living in the property, okay? Person A, the owner of the property, wants to sell the property, but they don't want to pay capital gains taxes on that appreciation of the property, and they don't qualify for the personal residence exemption, $500K, because they don't live in the house. But you have to live in the house, and you have to live there for 2 years, and you have to be the owner of the house to qualify for the exemption. So the fact that person B has lived there for 2 years doesn't matter if they don't own the house, okay? But then we have the other, so that's part one. The simple solution is, okay, person A gives the house to person B, okay? When it's a gift, you don't pay any excise tax, okay? There are no transfer fees with the state on a gift of anything. So you gift the house to the person, and then you let the person live there for 2 years, and they can sell it, and they won't pay any appreciation on that first $500K with that house. Okay, hopefully this makes sense. Feels like it's a little foggy for me right now. It's a little jumbled, but that's okay. I know you're following with me. I'm going to recap it again at the end, just to make sure. Okay, so we've got person A owns a home. He wants to sell it. He doesn't live in it. Person B lives in it. But he doesn't want to pay capital gains on the appreciation of the property over time. So he's going to gift the property to person B. Person B is going to live in the property for 2 years, and then person B is going to sell the property, and because they've lived there for 2 years, they will get that capital gains exemption on your personal residence. Right now, $500K, and everything will be right in the world. You'll save about 100 G's, essentially, ish. Okay. By the way, before you do any of this, go talk to me, go talk to Moses. All right, don't do this stuff on your own, because like one little slip up and the whole house of cards just crumbles to the ground. And we don't want that to you. I'm trying to give you some good ideas to get you to come talk to me, okay? Because there's a lot of fun stuff you can do. Now, let's throw a wrinkle into this problem, because if it's just that sounds great, okay? But there's a wrinkle. There's a mortgage on the property, okay? And the owner of the property, as you might expect, is the one that has the note on the property. That's the way that it goes. If the owner, if person A, gives the property to person B, the mortgage company is going to have a problem with that. There is a little clause inside of the mortgage called a due on sale clause that basically says, if these laundry list of things happen, we can call you up and say, you owe us the entire balance of the mortgage right now, okay? One of those due on sale clauses is the transfer of the property from one person to another, okay? There are many different reasons for that. One of the reasons is that the bank doesn't know who this person is that's getting the property. They don't know if they can pay the mortgage. They don't know if they're a good person or whatever, although you don't really have to qualify as a good person to get a mortgage. Well, I mean good in the sense of being able to meet the obligations of the mortgage. Then you have a separate problem of if you give the property to a third party and then they somehow like finagle a sale under the table to somebody else, now you have all sorts of crazy property issues jumping up, all kinds of like loan issues. If you're a real estate attorney, it'd be super fun and interesting. But if you're just a regular old person, it'd just be a pain in the butt, headache. So what do? This was the solution that I came up with that I thought was pretty interesting and would work. So if you know that you want to give property A, if person A wants to give their property to person B, but it has a mortgage on it, so they're worried about gifting it over and then having the bank call the loan, what I would do is talk to person B, who is going to receive the gift of the property. Before I made that gift, I would say, hey, person B, what I want you to do is go to the bank. I want you to get pre-qualified, like basically pre-set up for this mortgage, okay? And here's what's gonna happen. I'm gonna gift you the property. Right when you get the property, you are going to go and you are going to get this mortgage. You are going to actually apply for this mortgage and get it, okay? And most of the time in a scenario like this, it actually isn't going to be terribly difficult, assuming that you can just meet the basic qualifications. The reason for that is you're gonna have a lot of appreciation on a property like this, so the note is often going to be significantly lower than the value of the property. In this case, the actual mortgage amount was about 20% of the value of the property. You find me a bank that won't give you a note for 20% of the value of property, you're just a terrible person, because you must have some really bad credit or something else going on for you that's terrible, because banks love that. It's like a no-risk loan. No matter how much the property drops, they're still gonna get their money back. That's all I care about. So what you do is, the moment you gift the property, now the person B is the owner of the property, they go to the bank, they say, look, I own this property, I need to take out a loan for the amount of this other mortgage, basically to pay off this mortgage. They give the note, they give the loan pays off that other mortgage, you don't have to worry about the due on sale clause. Person B now owns the property, they have their own mortgage on the property, you can start the 2-year clock to avoid paying, or to actually qualify for that capital gains exemption, and then after the 2 years you can sell the property and you can do whatever you want. And I guess technically, in a perfect world, if we're scheming all the way to the end of this, the person that you give the property to, person B, after they sold the property, would then turn around and give the proceeds at least to person A, so that they could have saved that capital gains exclusion. If it's in the family, maybe you don't care, maybe you just want person B to have it, but that's essentially how you would do it. So if this made sense and you like it, hit the like button. If you have questions or comments, please let me know. I was jumping around a little bit, but essentially it is possible to gift a property and not pay any capital gains tax, or at least at on that first 500K of appreciation, not pay any excise taxes, and avoid the problem of having a note on the property and having a due on sale clause sort of initiated, or I don't know what the word is off the top of my head, called. You can do it all, okay? But the key is, don't do it by yourself, right? Really, if you call me, there's not even anything. What the terrible part about this is why I'm a bad attorney. In this whole what I've just explained to you, there's not really any work for me to do. There's nothing. I could draw up the deed for you, but that's like $50. Okay. You know, Moses is gonna make some money on this. The banker's probably gonna make some money on this. You are gonna make some money on this. I'm just gonna make a video and tell you how to do it, basically. But if you do want some help on that or any other estate planning issue, please go to estatemeeting.com. Set up a time to talk to me. I will talk to you about this. I will talk to you about your estate planning needs. If you have an estate plan, the terrible things that can happen to you if you don't at least have the basics. And not trying to convince you to do anything, but at least allow you to make an informed decision about protecting yourself and protecting your family. Because that's what's important for me. All right, that is it. I'm Christopher Small with CMS Law Firm. I hope you enjoyed this video. If you liked it, hit the like button. If you know somebody that needs to hear this, share it. If you have a question or comment, leave it. Otherwise, I will probably see you again